case was in the workers who are home health care workers in Illinois, the ones who don't want to be a part of the union, can they be forced to pay some of union dues? Even they're beneficiaries of the contract, but they don't want to be in the union. And the court said these workers in particular cannot be forced to pay their union dues. What's significant about the case is that the Supreme Court did not view these workers as public employees. They're home health care workers. They're sort of independent contractors, sort of government employees. So the decision is really just limited to these home health care workers. It's not about all public employees. And labor unions were particularly worried about a decision that would apply to all government workers. So it's a narrow decision, a loss for the unions, but it's not as catastrophic as many labor union people feared.
Much of the attention focus from this recent Supreme Court decision and the session was on the Hobby Lobby Conestoga case dealing with contraception and Obamacare. Lost in the shuffle, just a tad, was a decision involving public labor unions that can and likely will have wide-ranging effects across the American employment scape for years to come. That certainly is the fear that some have. Welcome to MidPoint. Chairman of the National Center for Public Policy Research, Amy Ridenour, joins us. Amy, thank you so much for being with us.
Glad to be with you.
Amy, let's get down to this. This is called by many a narrow decision. And again, we're dealing with an individual, a very small group of people in one state in the union. But let's always look, because when you have these decisions, sometimes they do grow and they start to affect many more people. There is that fear from private unions and other public unions. Is this indeed, in your opinion, a decision that will grow and that does have those tentacles and that will start to force change across the union landscape?
It could. It's going to depend on the future composition of the Supreme Court. If we assume the Supreme Court retains the current composition, my guess is yes. And yes, this is an extremely important case for the future of organized labor. A couple of reasons. First, this does not affect private unions. That would be a union that organizes, say, General Motors or GE or any of the companies that work privately for profit. This affects public unions, government unions. And the issue at stake, and many have missed this, is First Amendment, freedom of speech. Individuals were forced to pay service fees to a union, yes, only in Illinois so far. They didn't have a choice about it. They didn't join the union. They were told they had to pay service fees, and the service fees were not used for the sort of thing that typically one thinks they'll be used for, like a collective bargaining, like we'll work for $10 an hour. It was for the union to, along with a few other things that were sort of accounting things, to lobby Illinois and the federal government for expanded Medicaid spending. And that's because these workers did not work for the government. They worked for largely disabled people, elderly people who were on Medicaid. So they were indirectly getting taxpayers' money, but only because the people they worked for received public assistance. So the union was doing left-wing lobbying with their money, and they had no choice but to give it. And they said, that's a First Amendment violation. You're forcing me to pay for speech with which I disagree.
All right, Amy, I'm going to have you go back a little bit on this right now, because here's where some people are maybe having a problem with this. If you think about unions, you have individuals here who are not a member of the union. They're working in a situation where an agreement, a bargaining agreement, if whatever you will, is negotiated by the union. So the union is helping to set rates, is helping to set what they get paid, is helping to set protections. This is the perception that people have here. So then are these people not then taking advantage of what the union is negotiating, even though they are not paying union dues?
No, and that's because the union didn't do the things you just listed. These are individuals who work largely for their own members, the members of their own families. To be very specific about the plaintiff who brought the original case, this is a mom of an adult son who is severely disabled. She stays home and takes care of him. He gets Medicaid. Medicaid gives him extra money to have a home health care worker. Doesn't have to be mom, could be anybody, because the alternative is that he would go into an institution in Illinois, which is more expensive. But the union did not negotiate her wage rate. It did none of those things. Medicaid decided how much they are willing to pay. What the union is doing is it is lobbying Illinois to make more Medicaid payments. It's just as if it was food stamps and they were lobbying for more food stamp money every month, or any sort of welfare payment to say you should give everybody more than $500 a month. You should give them all $550. Just like you or I could go to a state capitol and say, we want you to do more spending here and less spending over there. That's all the union was doing. It was lobbying. So these people said, you're not doing collective bargaining, you're lobbying, and you're making me help you pay for it. And we don't want to.
You have delivered that very rare and logical explanation of many things that people normally don't get when it comes down to Supreme Court decisions. So then, judging by what you just told us, is there indeed any fear? Because it would seem as if what we heard on the soundbite coming in here is, don't worry about it, private unions, other public unions, this is not going to affect you, it is just that narrow. So from what you just said, it would seem then as if they're right, this is so narrow that it would be extremely difficult for the Supreme Court, or any lower court as a matter of fact, to take this and push this forward into another union arena. Yes or no?
It would not be difficult, but they would need a new case.
Okay.
Here's why. In 1977, a plaintiff first brought a case saying that they shouldn't have to give service fees to a public sector union because that union was lobbying for things with which that individual disagreed. The Supreme Court at that time decided that the man had a good point. But what they did was they split the fees. They said part of the fees are for collective bargaining, part of the fees are for political activity. The unions must make a list of how much is for politics, how much is for collective bargaining, and then that guy only has to pay a service fee for the collective bargaining. And that's what's been in effect ever since for labor unions. That's since 1977. Well, fast forward to this week. What happened in this decision is a majority said, we may relook at that 1977 case in the future and decide that actually public unions, that is unions whose members are public employees, actually are violating of the people that are paying service fees, because public unions actually have a dramatic impact on national public policy. So if they do that, then the only revenue that a public union will get is from its voluntary members. Now, that's not unfair in my personal point of view, because those are the people who want to be in the union. But that will be hugely expensive for the union, because they have, since 1977, and actually before that, gotten the money from people who had no choice about giving their money. And you get a lot more money when you can force people to give it to you.
All right, a few minutes I got left here then. What we have just discussed, I love going down this road because it opens up again so many avenues. But from what you've just said, there was an op-ed in the New York Times written by two law professors, and the title was "The War on Workers, the Supreme Court Ruling on Harris v. Quinn is a Blow for Unions." They point out here unions are already reeling. At a time when workers are losing economic ground, we should be looking for ways to strengthen their ability to join with co-workers and bargain collectively to improve their lot. From what you just told us, this entire article right here and this entire op-ed is completely incorrect, if I'm reading it right.
That's whoever wrote that. I didn't see it, but they are union apologists.
I'm gonna tell you who it was. It was Cynthia Estlund, a professor of law at New York University, and William Forbath, a professor of law and history at the University of Texas, Austin. Both wrote this, and it was on July the 2nd in the New York Times, a blow for unions.
Okay, well, they are union apologists. They are people who are more concerned about the unions having money than the workers. This decision gives workers more freedom. They are still free to give money to the union. They're still free to join the union. Nothing is taken away from workers. The thesis in that op-ed is that workers benefit from unions having a lot of money. This is debatable. First, we have an awful lot of regulations about what can happen in workplaces. We also have minimum wage laws and plenty of opportunity for people to better themselves with public assistance, with education loans, and so forth, so they can earn more money. 150 years ago, you could get very easily injured if you went to work at a factory. Today, you've got OSHA and state-based, systems to make sure the places are safe. If somebody doesn't pay you, you can go to court and you win. All kinds of things happen to take care of workers. The unions, they're not necessary as they were. Now, a few union people tell me I'm absolutely out of my mind because they're used to being able to file grievances. Well, guess what? Most of the workforce doesn't ever file grievances. They just go to the boss and work it out. And it actually does work.
One last thing, 20 seconds. Here it is talking about the fact that Service Employees International Union, involved in this case, this suit could spur class action suits to recover dues and could put them out of work. True or false? Put them out of business, I should say.
I do not see it putting them out of business. Absolutely not. They might have to lay off a few of the people at the headquarters or go play golf a little less often. But no way, they're not going out of business based on this alone.
Amy, you have just, as a matter of fact, set back the New York Times and their op-ed page at least a couple of days in what you have said, and certainly a couple of economists and lawyers are not going to be very happy. But indeed, you answer the questions from a factual basis, and that's why we like having you here. Amy, thank you so much for joining us today, and please have a wonderful 4th of July holiday.
You too.
All right. There you go. I mean, it's sitting right here. The war on workers. Guess they got it all wrong, didn't they? Well, we can find that out. And why? Because here on MidPoint, every single day, we question everything. We're back with more of the fastest 3 hours of news right here on the Newsmax TV network.